Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast for the American Bar Association Antitrust Law section. My name is Anora Wang, and today's topic is, what's the score, Your Honor? Conversation with Judge Richard Boulware. Joining me today is my co-host, Jeny Maier. Hi, Jeny.
Hey, Anora. Really looking forward to being here today.
So within the American Bar Association Antitrust Law, there are opportunities and treasured leadership positions, including one called the judicial representative. The opportunities that we have at our Curious Amalgam is each year that we get to sit down with a newly elected judicial representative to really give us opportunities to learn about them a little bit more as a jurist and as a person. So, Jeny, would you please introduce our guest today?
It would be my pleasure. Welcome. Our guest today is the Honorable Judge Richard Franklin Boulware II, who has been a U.S. District Judge for the United States District Court for the District of Nevada, where he has been presiding since 2014. He is based in Las Vegas, and he brings more than a decade's worth of federal trial experience to the bench. Before he took his job on the district court, he was a federal public defender in both Las Vegas and in New York City. After he served in a clerkship with Judge Denise Cote in the Southern District of New York. Judge Boulware is a longtime leader in the legal community. He is a past president of the Las Vegas chapter of the National Bar Association. He's been a past chair of the ABA National Conference of Federal Trial Judges, a recipient of many multiple justice and service awards, and most notably for our conversation today, serves as the ABA Antitrust Law section's judicial representative. So welcome, Judge Boulware.
Well, it's an honor and a privilege to be here. I'm happy to be talking with you all, and I look forward to our conversation today.
So we kind of kept it vague in the topic that we're going to have a conversation with you, but we really just want to get to know you a little bit professionally. So let's start with your earlier career. Could you tell us just a little bit about your experiences before getting on the bench and how they prepared you for your services on the bench?
Sure. I spent almost my entire career as a federal public defender. I clerked for a year in the Southern District of New York, and then after that, I worked briefly for a law firm, and then I went on to be a federal public defender, and I was a federal public defender for my entire time before I took the bench. And I think that's really important because at the time that I actually was nominated, there were very few federal public defenders who were being nominated to federal district court positions. It was somewhat unique at the time. There are more former federal public defenders as federal district judges now, but at the time that I was nominated, it was highly unusual. And I think that was really important, and it's still important because my experience having represented some of the most needy and indigent individuals in the course of trying to navigate our criminal justice system, I think was important work for me because I recognized the good things about our system, but also the sort of the bad thing, the things that don't work, and understood how the system could go awry and really come down hard on people because they lacked resources, because they didn't have access to community networks or family networks. And so when I took the bench, that was a really significant aspect of my approach to being a judge. You know, people often ask me, they say, well, what is the most significant aspect of your life that has influenced your approach to the bench? And people expect me to say it's me being African-American. And while that has presented me with a unique perspective in the world being African-American, my term and my time, I should say, as a federal public defender has by far been the most influential aspect of my judicial service because I understood and understand how important it is for the system to not just appear to be fair, but to truly be fair from a procedural standpoint for individuals, regardless of whether they're represented or not, regardless of what resources they have, regardless of their status, their identity, whomever they are. I recognize how significant it is that they feel that they are heard. So for example, one of the things that I do is I make sure that every single person who has a case in front of me gets at least one chance to see me in person. So I give everyone that gets a chance to have a hearing, gets a chance to tell me one time what's going on. And I'll ask them, tell me what happened. Tell me what's your story. Particularly where I sit, we have a lot of individuals who represent themselves. We have a lot of prisoner civil rights cases. And so I think it's very important for these individuals to feel heard and to feel seen. And for me as a judge to say, I want to know what happened to you. It doesn't mean that I'm going to rule for you. It doesn't mean that you're going to prevail, but it does mean that you'll have one chance. In this case, it's so important to you to tell your story.
That's really meaningful. And how have you been able to operationalize it beyond just having that initial conversation? Are there other aspects of your time as a federal public defender that you have, translated into your job on the other side as behind the gavel?
Well, I think the hearings are one part of that. The other part of that is trying to write orders in plain language, right? Understanding that, when people don't have legal training are reading your orders that affect their lives so significantly, they should be able to understand what it says. Now, they may not be able to follow the legal citations that we use, but I try to make sure in my orders, I write them in such a way that the average person can understand the plain language of the order, understand what it is that I'm saying in the order, understand why I'm ruling the way that I'm ruling. And so those are two really important aspects for me of making sure that this is about what I call, and I say in my chambers, it's about everyday justice. Like, there are a lot of cases that get the big media attention and they get all of the focus, but I still, we want to do everyday justice. We want to do justice and afford people justice who are not the ones who are on the front page of the newspaper, who are not the ones who have a bank of lawyers there, right? It's about every person every day receiving the justice that they deserve under the law. And so that's been my focus. And that's sort of the way that I approach it. And that's what I tell my chambers staff and my clerks, that, again, we want to do everyday justice because these cases, each case is for that particular person or those parties, the most important case of their life, usually. And so we want to make sure that they don't feel that somehow we're giving priority to other cases that may, quote unquote, have a higher profile.
Really important also, I think, even for practitioners, I think I could appreciate, and I'm sure that all of our fellow lawyers do, anything that is communicated in clear, plain English, regardless of the audience for the order or for your decision, accrues to the benefit, I think, of everyone.
I agree.
Let's talk a little bit about your transitioning from an advocate to be from advocate to be adjudicator. What was the most surprising part? I know your career as a public defender prepared you well, and you may have started fashion. Now we do see more of former public defenders on the bench now. But are there anything that's surprising to you when you first got to the bench? Something that you couldn't have understood, or you may have to unlearn after you get on the bench?
Well, certainly I think sometimes the most challenging thing is I'm a former trial lawyer. And so when I see things happening in trial, as a former advocate, I think to myself, they could have the question this way or asked it this way. They could have made this objection. And I have to say to myself in the back of my mind, look, that's not for you to do at this point. You are not on either side of this. And so one of the things I actually teach my law clerks to help train them is I will send them a little text and I will say, this lawyer could have made 2 objections to this question. When we get a break, I want you to tell me what those 2 objections were. So that's one of the ways I sort of deal with my former trial attorney sort of persona, is I have to give it a little bit of space. And so I do that where we have what we call sort of trial time during my trial breaks in my chambers. And so we go over what are the things that lawyers could have said that they didn't say, what are the arguments that they could have made that they didn't make. And so that's the best way that I can, in some ways, if you will, exercise my sort of former trial persona when I'm in a trial. But I still enjoy presiding over them, but I just have to sometimes bite my lip a little bit.
So fun. You're a referee, in like, sort of like in analogy to sports, you're a referee of the size that's presenting in front of you, but you're also a coach to your law clerk. You're still trying to teach them along with the game. So that makes a clerkship with you an even more attractive position. People should consider that, law students.
Well, and I sit in Las Vegas, and so that's actually a great place to sit. Despite the lights and the glitz and the gaming, we have great food. So if you're a foodie, come to Vegas and clerk.
Not that you need advertising for that clerkship position. That's attractive already.
Right.
So since we are sitting in antitrust law section, so we want to talk about some antitrust cases that you may have handled, not specifically, but just in a general sense. How do you prepare yourself? What is your approach to preparing for an antitrust case as different than any other case? I know you do handle cases that's not antitrust, but is there anything directionally different?
So my first antitrust case was actually a fairly large case involving the UFC and fighters. It was a monopsony case. And you try to say that word 5 times fast, I guarantee you cannot. I didn't even really understand what it was until I went into the paperwork. And that case was sort of like drinking from a fire hose. But what it taught me was antitrust cases require detailed preparation and review. And so for that case, for example, I spent months reviewing reports and details and everything. And for all the cases that involve antitrust work, because they often include detailed analysis on markets or pricing, or actors within a market or agreements, it's very important for the judge at an early stage to understand the detail. In many of my other cases, I understand some of the details, but oftentimes the details don't come to me until a motion for summary judgment is filed. My experience is in an antitrust case, the sooner you familiarize yourself with the explicit details of the case, the arguments of the parties, have an opportunity to look at sort of the expert reports, as they're almost always going to be presented some sort of Daubert motion early on, right? That is a significant difference. Right, the level of detail that you have to go into as a judge earlier in the case, and the fact that it is a very unique field in terms of some of the concepts that are not concepts that we deal with on an everyday basis, right? So, I mean, people may think about it, but when you start talking about anti-poaching agreements, you start talking about the merger guidelines, you start talking about Section 5 of the FTC. These are all areas that are not common, that lawyers frequently don't come across, that judges frequently don't come across. And so you're also dealing with an area of law that has its own unique history, that it has a robust sort of case law and history. And so it's really important to take your time, particularly when you get your first antitrust case, to go through the details of the case, the regulations, and the law. And I learned that with those cases that I had, and that's continued to be my practice and my approach to antitrust cases, recognizing their sort of uniqueness as it relates to the detail and the concepts and the regulations.
Recognizing what you just said, that antitrust cases are very detailed, they turn very closely on the facts and how they are presented to you. The nuances between the facts can make a lot of difference in an outcome of a case. How do you see advocates that appear before you making a presentation that's effective versus a presentation that may be less effective for you?
I think what is effective for advocates in the antitrust space is to not assume that the judge will be as familiar as they are with some of these concepts and regulations and the law. Now, it doesn't mean that you adopt necessarily a patronizing tone with the judge, because that's not going to work. But it does mean that you present the information in a way that allows for the absorption of the information by the judge, right? and it's sort of an easily sort of digestible way, and present the material that way, in a clear fashion that explains it in a layperson's terms. Because, again, even within antitrust, there are specialized fields, right? And you can know one aspect of antitrust law, but you may not know another aspect of it. And so what I have found is that the practitioners in these areas often are very familiar with their particular area of antitrust law, right? And sometimes they're making these assumptions that the judge may know about how these regulations or how the law works in a particular area or certain seminal cases. And while the judge, I did, prepared for that, I still needed to have time to absorb their arguments, consider them. And so I think it's important for practitioners to be very thorough in sort of providing that background and foundational information, right? I also think one of the things that can be an approach that doesn't work as well is in particular, assuming that the lawyer can just tell the judge how this area of law works and that the judge will accept that. So I think, and in any sort of situation in court, it is certainly not advantageous to say to a judge, well, I know you may be new to this area of the law, so let me try to explain it to you this way. Now, there are ways to do that without saying it quite like that, but I do think that the most effective litigators and advocates in any area of the law are those who recognize that judges prepare and they get put in their positions because they're recognized for being able to absorb legal information and analyze cases and issue decisions, but they may not be knowledgeable as the particular practitioners in that area of the law. And so you have to be effective at sharing foundational information, reviewing foundational information, and most importantly, answering a judge's questions, right? Often, I ask the attorneys questions and they just will skip over my questions. And to me, that is a really missed opportunity because the judge's questions tell you, right? This is where the judge is thinking. This is what needs to be explained. This may be a sort of an area of your argument that is not clear or that is not as strong as another area. And so you simply jumping to your PowerPoint, right, and saying, well, let me go through the PowerPoint first, ignores an opportunity. When a judge asks a question, you should answer that question first. And then you can move on to your arguments. But the fact of the matter is you should think to yourself, if she or he asked this question, what does that tell me about my argument? What does that tell me about their approach to this particular topic? And so I find that particularly in the area of antitrust, the lawyers are not always as good as they should be at answering the questions from the judges. And I've actually heard that from some of my other colleagues who have also had some of these cases for the first time. They say that I'm trying to ask questions, I'm trying to figure this out, I'm trying to get information from them, and they keep going through their 50-point PowerPoint presentation, and that just isn't working.
As you were discussing just a minute ago, the feature that I think a lot of us in practice tend to rely a lot on PowerPoint. You are also a trial lawyer for many years. What is your view on sort of the pluses and minuses of using that method of communication in the courtroom?
Okay. When I was a trial lawyer, I never used PowerPoint. I would use demonstrative exhibits. I would use slides, right? But I think if you're making an argument, people should hear it from you. Now, if you want to emphasize a particular fact or figure as a demonstrative, I think PowerPoint can be useful for that, right? And in the constant antitrust case, if you want to show a particular sort of market trend, or you want to show something about pricing, or you want to show something about other economic analysis, okay, you can use a PowerPoint for that. But to put on the PowerPoint basically an argument that you could say out loud seems to me to really distract from the lawyer's direct connection with the judge and their persuasiveness. And I always found that to be the case as a trial lawyer. I wanted the jury to be looking at me, not at the PowerPoint on the screen or up on the screen, because if they're looking at the PowerPoint, they're not looking at me and they're not listening to me and I'm not able to make eye contact with them. And that also works with judges, right? If you have your PowerPoint, then I'm looking at your PowerPoint. I'm not looking at you. You're like this background noise behind me, but I'm not actually seeing you. And we have to remember a lot of communication is about nonverbal cues, right? And that's actually one of the powerful aspects of your advocacy, right? And how you present yourself. It is not just what you say, it's how you say it. And I think that's a lost art sometimes. And so we get so lost in the details of our case. And antitrust lawyers in particular, they're getting hyper-focused on the experts' reports and the details of the report and how their opponent's expert doesn't have this detail or that detail. And they're highlighting that in their particular PowerPoint. And some of that just gets lost in this PowerPoint presentation. And so I would discourage people from using it except as a demonstrative, to highlight something, right? Not as an argument, but to highlight. You want me to focus on a particular fact or figure, use that. Boom, there it is on the screen. Hey, okay, now I see it. Now I know what you're talking about, right? And then you take it down, right? It's also distracting if you're talking to me and it's up while you're talking to me, right? So I've got you talking to me. I'm supposed to be looking at you. Then I'm looking at the PowerPoint. Then I'm looking at you, and I'm going, right? That is not an effective way, from my standpoint, to communicate. So, I didn't really do that as an advocate. I don't really encourage the lawyers to do it. And again, that's not to say you can't use demonstratives, which are different. It's not to say you can't use slides to ask questions, to present a central question. That's different. But if you're essentially making your argument with bullet points on a PowerPoint that you could say out loud, that is not effective in my view.
I can relate to some things you just said, like, lawyers going back to their talking points or going to talking points on a PowerPoint. It gives us a little bit of security.
Right.
I feel like I have something to come back to, but we totally get your point. That's perhaps not the most effective advocacy.
Well, the thing to remember about that is that I also can appreciate a lawyer's knowledge of their case and their opponent's case if they can respond to me without looking at their notes. That tells me they understand their case, they understand the other side's case, and they understand my question. So if you're able to do that, that also speaks to me about your preparation, how well you understand all the different competing perspectives and views, how well you understand the different cases, right? And so I think that being able to move away from your notes, right, even though they can be a bit of a security blanket, can be very effective. And so I think that's about just anticipating questions. Because one of the other questions you had asked, or the question you had asked, was also about just effective techniques. The other sort of really effective technique really relates to just anticipating the questions that the judge might have, or anticipating questions or issues that the other side is going to present. I'm oftentimes surprised when I have lawyers who come into court and their questions, which they easily could have anticipated would be asked by the judge, and they don't have a particularly persuasive answer. It's almost as if they never anticipated getting the question because they were so convinced of the rightness of their argument. Well, as lawyers, we're all taught to immerse ourselves in the rightness of the argument. But as an effective advocate, you have to at least be able to respond to and understand the opposing side's arguments or questions that you may get from a judge that might explore areas of your argument. And so anticipating arguments, right, and being prepared to respond is another really important aspect of being an effective sort of litigator and advocate.
So that we can just get a little bit more advice from you as practitioner. And then we was talking about effectiveness. Another thing that lawyers in front of you should really try to achieve is to build basically a trust, right? Like, to have the judge's trust. Are there any courtroom habits or practices that would instantly just gain or lose a lawyer's your trust in that lawyer?
Sure. One of the things that people often don't focus on is how you treat the judge's court staff before the argument gets started. So if you were disrespectful or rude or abrupt with people in the courthouse, people in the courtroom, right? That is going to set a tone, right? And you can see it, right? When you're preparing, you can see how some of the lawyers will interact, right, with the sort of people in the courtroom. And that can set a very positive or negative tone depending upon how you interact with the people in the courtroom. And so I find one of the easy ways, right, to set a positive tone is positive, helpful interactions with court staff. Ask them, is there anything that I can do as course this argument that will be helpful for you? Are there any particular procedures that I should be aware of so that I make it easier for you if I'm requesting a transcript or if I'm going to present something in a PowerPoint? So just let me know how I can make this presentation easier for you. I know that the judge is the focus, but I also want to make sure that I'm working with you to make this a smooth presentation. And so I've seen lawyers do that. And when I come out and I see, my staff is smiling, they're engaging, that's a easy point for your side, right, when it happens.
Well, maybe just to switch gears a little bit
Sure.
and talk about the reason why we are here talking today here at the ABA Fall Forum. As we talked about at the outset, you are taking on the role of the ABA Antitrust Judicial Representative. Can you tell us about some of your objectives for the year?
Sure. One of the main objectives that I have is to make sure that we bring more federal judges and more practitioners and regulators, enforcers, experts together to be able to have this conversation about antitrust law. Antitrust law, I think, is in a unique period at this point where there are opportunities for having conversations about how it's evolving in terms of some of the challenges that we see, some of the new aspects of our sort of economy, sort of this AI economy that's rising. What can we do to sort of address some of the issues that are coming up? And from my perspective, I think all of us who are in this space need to have opportunities to be able to have conversations with one another. And so one of my goals is to try to make sure that the section hears from a variety of different voices from the bench and to bring judges together with all of the other sort of individuals who operate in the space so we can have some interesting conversations about antitrust law. And so I'm working with the section to make sure we have opportunities for judges from all over the country to be able to participate in events with the section. Additionally, one of the things we're working on, actually, which hopefully will start in the spring, is a trial academy. So a federal trial academy where what we're trying to do is to develop at the spring annual meeting the trial academy where lawyers would come in about a day ahead of time and they would have a full day of trial training with a federal judge and a senior litigator. They get an opportunity to be able to do an opening and a closing, to do examinations, direct and cross-examination. And this would all be in a very structured setting with materials that we would create, but it would be an opportunity to truly develop trial skills and to have the input of a federal trial judge and a senior trial litigator for these lawyers as part of the trial academy. And that's going to be something that we're hopefully rolling out at the spring meeting next year. So I'm really excited about that and hopeful that we'll be able to finalize the details of that and be able to announce that sometime in January. But that's one of my main objectives for this coming year, is making sure we get the trial academy moving forward. And that will be with also the National Conference of Federal Trial Judges, where I was a former chair. And so they're going to be a part of that, hopefully, as well. And so that also brings different aspects of the ABA together. But this really is an opportunity for antitrust practitioners, right, particularly younger lawyers, to be able to develop trial skills, to be able to develop in the context of experienced federal trial judges. That's a unique opportunity that we want to be able to present.
What an invaluable opportunity. And as if there was not already enough reasons to come to the spring meeting anyway. That just sounds like a real peerless opportunity for lawyers in this space, because we don't get those opportunities very often. So that sounds amazing.
And
Well,
I'm sure more information will be available on ABA website.
Oh,
when
yeah,
we
this
get
is just a little
closer.
bit of a teaser,
Yeah,
right?
yeah.
This is just to let you know that this is coming, right?
Yeah.
And so get ready for it. When we see it, you know that this is coming, because initially there'll be very limited spots. And so it'll be first come, first serve. And so when you see the announcement, you're going to need to move quickly. Otherwise, the spots will fill up, I assume, fairly quickly.
Yeah.
I don't know if there are other questions you have as it relates to the liaison.
I do have one thing related to your position as the judicial representative. I think you already very effectively communicated outside of the judiciary, which is awareness of the increasing threats to judges personally. So is there anything, because we think you are bridging the gap between the legal community and the judiciary. So tell us from your perspective, is there anything that lawyers can do to help reduce the risks and frankly, just threats towards the judges?
No, I think having conversations about it is significant. I think one of the things that's a challenge for the judiciary is that, we don't give press conferences, and we're not supposed to be giving press conferences. That's not our role. Our role is to decide cases, and that's where we essentially speak for the most part. We do come to professional conferences, like conferences held at the ABA or other legal professional conferences, and we have an opportunity to speak at those conferences. But the lawyers have an opportunity that we don't, to be able to have these conversations in a public and open way that simply is unavailable to us as judges. I absolutely believe, and I have said this on different occasions, but there is a rise in threats to the judiciary. I've experienced those threats, and unfortunately had a case in which a woman was prosecuted for making direct threats to me and my family and my children, right? And people don't recognize how there has been an increase in threats to the judiciary. And so having the open public conversations about this challenge, about this security threat, right, can be, I think, an important role that lawyers can play. Because, again, as a judge, we typically, and the members of the judiciary, we typically are not engaged in sort of forward-facing public relations events, because that's not generally our role. And so the lawyers can help with sharing and disseminating information about the nature of threats to the judiciary and having conversations about resources that may be allocated to address security concerns.
Right. Well, thank you for raising the awareness and for letting us as practitioners know what we can do to help support that as members of the bar and individuals who have sworn to uphold the rule of law. It's certainly important for us to hear and for us to do our part to support that.
Well, I appreciate you asking the question, because it is important to us. And I talk to my colleagues, and we expect a certain amount of scrutiny that comes with it being a judge and the decisions you issue. But many of my colleagues are concerned about the rise in threats to themselves and particularly their families. And so I appreciate you asking the question. I appreciate the support of lawyers in the community recognizing the need for us to take this seriously as part of all the members of the bar and the rule of law, because it is something that is necessary to address because of the need to protect the rule of law that can be affected potentially by a rise in threats to the judiciary.
Now let's shift gear one more time. We always seize the opportunity whenever we can. We get, especially when we have a judge on, we would like to know you a little better as a person. We just talked about how it's important to protect your personal safety. So we're not going to try to extract any personal information that they're not willing to share. But is there anything you can share with us who is watching that people would usually don't know about you if they have only dealt with you professionally?
If they haven't, I would say I love to do karaoke. So I am a karaoke theme, right? And so, because of course I don't sing on the bench as much as I might love to, I find other opportunities to be able to sing and express myself, and so I think my family isn't always so happy about that. I'm not saying that I'm good at it, but I am known, right, to grab a microphone if there's music playing and to start singing some of my favorite songs. And so I don't know if that's something people would know about me, just seeing me in my robe or reading my bio or CV, but it doesn't take that long to get to know that I enjoy karaoke, enjoy singing with friends and family, and so that would be something that you would never really know.
Go-to song.
Ooh, do I have a go-to song? I say Sweet Caroline by Neil Diamond.
Great choice. We look forward to perhaps even hearing some of that at a section event. It has been a great pleasure to speak with you, and thank you for sitting down with us, and thank you for watching. It has been a pleasure.
Thank you for having me. I look forward to continued conversations with members of the section. So thank you very much for having me. It's been a privilege.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.